Welcome, everybody. We're so happy that you joined us today. I'm excited for Ashley Sherwood to talk about contract clauses for small businesses. So what should you be keeping in mind? And we'll get to Ashley in just a moment. Because there are, I see several new names, so welcome. I'm glad you're joining us. A little bit about what's going to happen today, so some housekeeping before we really dive in. This webinar is being recorded. So if there's something that you want to listen to again or revisit, you'll have that in your inbox by the end of today. Please mute yourself because it is being recorded, and to make sure that everybody can hear. Sometimes we have, people typing or, kids crying, dogs barking, fun stuff like that. So just mute yourself. You can unmute yourself later. You don't have to stay muted forever should you want to ask a question. If you're having issues with audio, if it's cutting in and out, I recommend using the phone dial-in rather than the computer audio. It seems to be a little bit more reliable. In your GoToWebinar control panel, there is an audio section that you can select phone call versus computer audio. And then if you have questions, you're welcome to raise your hand, which is this blue icon with a little hand symbol, and that'll let us know that you want to verbally ask a question, by unmuting yourself. Or you can type it into the chat box, and we can see it that way. We are going to reserve all the questions to the end because Ashley has a feeling that when you have a question, it might be answered in a few slides. So feel free to send them in as it goes so that you don't forget about it. And then a little bit about me. My name is Traci Hansen. I'm with the Washington Center for Women in Business, and we are an SBA-funded women's business center. And our goal is to help women in business who want to either start a business, or if they're already in business, how can we help you grow in a successful way, and can we help you fill those knowledge gaps? So you might be passionate about the business that you do, but you might struggle with understanding financials, cash flow, other legal requirements, operations, how to hire somebody, marketing, social media. We try to help fill those gaps for you. And we do this in a variety of ways, workshops like this, either online or in person, or a lot of one-on-one coaching. We sit down with you and kind of make a customized plan to help you get to where your goal is. And we cover the entire state of Washington. I'm physically located in Lacey, Washington. So if you're not in Lacey, we have a lot of technologies that can help us meet together, whether it's phone calls, Skype, GoToWebinar like this, screen sharing. It is free to meet with us for the first time. After that, it's $25 for an hour session. However, we have a lot of different scholarships and fee waivers available. We never want the price to be a barrier for you to get the business information that you need. So please don't hesitate to ask, and there's our contact information. And with that, Ashley, I will switch it over to you.
Great, thank you, Traci. Let's see if I can figure this out. Alrighty, hopefully you guys are seeing on the screen what I am seeing. Good afternoon.
Notes version. If you click the display settings in the PowerPoint, it should let you swap the screen. Yeah, right there.
How about that?
There it is.
All right, perfect. You guys don't want to read my notes anyways. They're chicken scratch and shorthand. So good afternoon, everyone. Thank you so much for spending your lunch hour with me. As Traci said, I'm Ashley Sherwood, and I have the pleasure of speaking to all of you today about contract clauses for small businesses. I will try to keep the presentation to about 30 or 45 minutes or so that we have enough time for questions at the end. Also, my contact information is on that first slide and also at the end. So if you need to jot down my email address, and if someone reminds me, I'll give you my direct dial at the end also if you guys have any questions about the presentation. So a little bit of background about Old Morrison, the firm that I work for, and myself, simply so that you can have some context about my perspectives and kind of the advice that I'm giving today. Old Morrison was founded in 1893 by this lovely gentleman named John Condon. The firm was originally called Condon Wright and evolved over the past 120 so years into Old Morrison, Rinker, and Baker. Our founding office is in Seattle, but we also have offices in Oakland and Anchorage. And while many of our clients are based in the Pacific Northwest, we do represent large and small clients from all over the country and all over the world also. So a little bit about me, again, to provide just some context for my perspectives. There I am. I'm a Seattle native. I grew up just north of Seattle in Bothell, Washington. I got my undergraduate degree at the UW. I was a business major at the Foster School of Business. After graduation, I worked for an accounting firm for several years and then also attended law school at the University of Washington. And after that, as they say, the rest is kind of history. I've been working at Oles as an attorney for almost 5 years now. Still a fairly short career, but have been lucky enough to have quite a bit of on-the-ground experience here. And I advise a wide range of clients on a variety of commercial disputes. Recently, with all the economic growth in the region, though, a lot of the disputes I'm dealing with right now center around development and construction, both in the private sector and in the public sector with agencies like Sound Transit and the Washington State Department of Transportation, meaning I'm down in Thurston County quite a bit. Okay, so what are we going to cover today? Let me precursor this by saying there are week-long seminars dedicated to this topic. And what we're going to talk about today by no means is intended to cover everything that you should know, but it does give a good primer on the main points and what you really should be looking out for, whether you're concerned or looking into an existing contract you might have, or whether you're negotiating or drafting future contracts. So the first thing we'll cover is, do I always need a written contract? The next is, what clauses should I be including in my contracts? What if the company or individual I'm contracting with won't budge? So for example, if you're dealing with a larger company or even, a smaller, medium-sized company that slides their form contract across the table and says, sign it or no deal. So we'll talk about that a little bit. And then, like I mentioned at the end, we will leave some time for questions. So the first thing we're going to talk about, do I always need a written contract? I'm going to caution you, because this is kind of a very lawyerly answer I'm going to give you, and it drives me nuts when other lawyers use it, that sometimes it's appropriate. And really the answer is, it depends. Oral contracts are enforceable in Washington so long as the essential elements of a contract are there. When I say that, I mean mutual assent to the essential terms of the contract, consideration. So for example, I will give you 12 bananas in exchange for $12. So long as the essential terms are there in an oral contract, those contracts will be enforced in Washington. Now, I say that, but I generally do recommend to my clients that they put things in writing. It makes things a lot easier down the road, and you can really avoid a lot of headaches if you even chicken scratch it out on a piece of paper or formally type out kind of the basic terms of the agreement. I also let my clients know that some contracts actually must be in writing in order for those contracts to be enforceable. And there is a legalese phrase for that. It's called the Statute of Frauds. And what the Statute of Frauds says essentially is that certain contracts are void unless they are in writing. And there really are 6 general categories of contracts that fall within the Statute of Frauds, or in other words, 6 kinds of contracts that do have to be in writing. The 6 are up on the screen right now, and some of these are going to be more applicable to most businesses than others. But I'll kind of go through some of them just in case they jog anyone's memory about a contract that they might have or might be looking to enter into. The first, which is probably most applicable to most people and businesses, is contracts not performable within 1 year of the time of the contract. So an example is if you have a contract with a landlord for a 3-year lease. So the term of the lease is longer than 1 year. So in other words, the contract isn't going to be finished in a year. It's not going to be performable in a year because it's a 3-year lease. So something like that needs to be in writing. If it can't be finished in a year, it needs to be in writing. The second category of contract that needs to be in writing is payment of another's debt, default, or what the statute uses, that's my favorite, is quote-unquote misdoings. This is really more limited than what it sounds, and applies when someone's paying off the debt of another that the person isn't going to benefit from. It's called a collateral promise. So for example, if you have a relative who takes out a car loan and you agree to pay off the loan, but then let your relative keep the car, your promise is a collateral promise, and that needs to be in writing. Now, in contrast, if you're going to benefit from paying off that car loan, so you agree to pay the car loan, but then you also keep the car, that's an original promise, and that's something that doesn't need to be in writing. There really are a lot of nuances to this payment of another's debt kind of exception, but that's really generally how it works in its most basic form. The third is promises by an executor or administrator of an estate. This is similar to the previous one we talked about, payment of another's debt. So if you're going to pay amounts out of an estate to cover the deceased person's debt, that also needs to be in writing. The next type of contract that needs to be in writing is an agreement authorizing a real estate commission. Now, this doesn't impact the sale of real estate between a buyer and a seller. That's a separate contract that's also subject to the Statute of Frauds that we'll talk about in a second. But the contract for the commission from the sale needs to be in writing, otherwise it's void. And I'll tell you, I thought that was kind of a unique exception, a unique carve-out for something that needs to be in writing. And I really couldn't find a good explanation from the legislature who drafted the statute or really case law explaining why a real estate commission in particular needs to be in writing. So I don't have a good story or example for you on that one, but if I find one, I'll certainly let you guys know. The next is sale of the land, and this is actually real property. So any promise to transfer an interest in land, or if you're creating an encumbrance, so for example, an easement, a walkway over someone's property, you're going to be able to build a fence on someone just past someone's property line, and they're going to let you do it. Something like that needs to be in writing. And the purpose for that is really to keep title of the property as clean as possible. Many people record those types of instruments when they do sell the land or grant an easement, things like that. And so it just kind of requiring that it be put in writing kind of keeps title to the land as clear as possible. And then finally, marriage. Washington law provides that promises to give money or property in exchange for a marriage or a promise to marriage must be in writing. Now, it is kind of a little of an archaic Statute of Frauds example, but there is one good example from a 1953 case out of the Ninth Circuit where a man included in his marriage proposal a promise to the woman he was proposing to leave all his property to the bride's children that she had from a previous marriage. After he died, oops, we're going too quickly. There we go, let me go back. There we go. After he died, the wife tried to enforce the promise, and the court held that it actually was unenforceable. So going on to the next slide, again, I just want to emphasize that in general, even if you might find yourself in a situation where an oral contract is acceptable, so if it doesn't fall into one of the categories we just talked about, I do advise my clients to put the contract in writing if you can. Like I said, it doesn't need to be anything formal. It can be scratched on a napkin or a piece of paper, but it really helps you to avoid headaches later if you put it in writing. And also when you're putting a contract together and stopping and thinking about it, you often think about certain things that you want in the contract that maybe that really didn't matter to you or you didn't think of had you just talked about it orally with the person or entity that you're contracting with. So next topic, what clauses should I include in my contract? And one of the things I want to start with saying is that contracts really aren't a one-size-fits-all concept. I've seen contracts that are hundreds of pages long with 30 attachments, and sometimes they need to be that long in order to capture all the terms that the parties want included. But in the same vein, I've seen excellent one-page contracts that include everything that the parties need to create a binding and enforceable contract without having to kill a tree in order to get it done with all that paper. The other thing I want to say before we kind of get into what you should include in your contract is it really is important to consider which side of the coin are you coming from when you're putting together your contract. So what I mean is, for example, are you the party that's receiving payment under the contract, such that you'll want to charge interest on a late paid invoice or bill? Contrastly, are you the payer that might not want to be penalized for making a late payment? So as we're going through this, really think about the clauses that might benefit you and those that maybe you don't want to include because they might penalize you in the long term. So here are 5 key clauses we're going to talk about today. Again, certainly doesn't cover everything that you'd want to include in a contract, but these are some of the 5 biggies that I like to look for in a contract or include if I'm drafting a contract. So payment term clauses, notice provisions, contract integration and modification, disputes clauses, and then limitations of liability. We'll go through each of the clauses briefly, kind of touching on why we care about each of them. We'll look at some sample language, and then we'll talk about some examples as we go through. So first up, payment terms. So what are these clauses? A payment term really provides what you need to be paid, what you need to submit to be paid, when you'll be paid, and what are the consequences if you don't get paid. We do the work because we want to get paid. So knowing when you get paid, what do you need to do to get paid, and whether you'll be compensated if you want to get paid on time really are issues that nearly every business owner really cares about. So here are some sample clauses. The first example, ABC contractor shall provide monthly invoices to the owner listing the work performed through the date of the invoice. So again, depending on whether you're the one getting paid or the one paying the invoices, all of these example clauses might change a bit. So with respect to this first example, if you're the one paying, you might not want to have to submit a lot of detail to back up what you're asking for. But in contrast, if you're the one making the payment, you probably want to see as much detail as possible so you know exactly what you're paying for. The second example, the owner shall pay invoices within 10 days of submission by ABC Contractors, Inc. So in terms of timing of payment, 7 to 10 calendar days, sorry, I thought I had X'd out this inter-office chat thing. So in terms of timing of payment, 7 to 10 calendar days after the submission of the necessary invoices is usually standard. So this allows the payer time to get the check there, clear up any issues with the bank prior to payment, and then if you're the one receiving the payment, 7 to 10 days is usually a short enough time period that you can survive that week or so waiting for that check to come in. The third example, 12% per annum interest shall be charged on any invoices not paid within 10 days of submission by ABC Contractors, Inc. So typically parties will agree that if payment isn't made on time, interest will be due. 12% per annum or 1% a month is the rate that I typically see in most contracts, although that can obviously be adjusted to a higher or lower figure. If you're the payor in the contract, interest on unpaid invoices is something you might not want to include. So again, keep that in mind when you're drafting or negotiating your own contract or reviewing a contract that someone has put in front of you. Next up is notice provisions. So what is a notice provision? These provisions provide the time frame and information required for notice of certain events or conditions. So let's look at an example first of a notice provision. Tenant may terminate this agreement by providing written notice to landlord no later than 30 calendar days prior to the date the tenant wishes to terminate its lease. Notice provisions in Washington are very important because actual notice in Washington state is not sufficient. So what do I mean by actual notice? So in the tenant-landlord example that you have on the screen in front of you, it's not enough that the tenant would orally tell the landlord 30 days in advance that it wants to terminate the lease. Even though the landlord has actual notice that the tenant wants to terminate the lease because the tenant told him or her, such notice isn't sufficient in Washington because it doesn't follow the precise language of the contract. So what's missing in that example is that the notice was oral and there was no written notice. the majority of states, I will tell you, your oral notice would have been sufficient because even though it's not in writing, the landlord did in fact have notice. They had actual notice, and it follows kind of the spirit of the agreement. But that's not the case in Washington. It's still really one of the few states that requires 100% compliance with notice provisions. The courts in the state are kind of slowly chipping away at the standard, and the legislature is trying to figure out kind of a statutory fix to this pretty harsh standard, but for now it really is still the law. Next up is contract integration and modification. So what is this? These clauses, they're sometimes combined into a single clause in a contract, and they really do two things. The first is it tells the parties which documents make up their contract, and the second, it provides a process by which to modify the contract. So let's look at some examples. So the first example is the parties' contract consists of this agreement and ABC Contractors, Inc.'s July 1st, 2017 proposal, paren, attached here to as Exhibit A, close paren. The second example is the parties' contract can only be modified in writing and only if such writing is duly executed by the parties. Now, in the first example, Washington law provides that parties can either attach documents to a contract to make them a part of the contract, so like in the example it says attached here to as Exhibit A, or you can refer to documents that aren't even attached and incorporate them by reference. So if we were to revise the example that's on the screen right now, the first bullet point under examples, it would be perfectly acceptable just to say the parties' contract consists of this agreement and ABC Contractor, Inc.'s July 1st, 2017 proposal without even attaching it. It's sufficient in Washington that things be incorporated by reference. That's generally the rule in most states, but again, just check kind of your local state rules if you are negotiating or entering into a contract outside of Washington. As to the second example, I have seen contracts before, particularly with a behemoth company and a smaller company, or individuals, where one party tries to include a clause that says company XYZ can unilaterally modify the contract. Now, you don't want to agree to that term generally for some obvious reasons. You know, you want to be informed, and you certainly want to have a say on when and how your contract gets modified. And again, that modification usually needs to be in writing. Like we talked about before on the statute of fraud examples, the same general rule applies to contract modifications. So for example, if you have a contract to build a school and you put that contract in writing, and 6 months later the project developer decides he wants to sell you some adjacent land and the two parties want to modify their existing contract to provide for the sale, that modification has to be in writing. So the modification, just keep in mind that the same statute of fraud rules apply to not only the main contract, but if you want to modify the contract to add other obligations also. Up next is disputes clauses. So disputes clauses tell the parties essentially what happens if they disagree about anything having to do with the contract performance. So the obligations under the performance, payments under the performance, breach of the contract, anything like that. Here's an example. It's a fairly long one, which is, bear with me while I read through it because there's a couple different subparts in here I want to talk about. In the event of a dispute between the parties agree that such dispute shall first be submitted to non-binding mediation to be mediated by a third-party individual agreed upon by the parties. If the mediation is unsuccessful and a party elects to file suit, Thurston County Superior Court shall be the exclusive jurisdiction for any such suit. Now, I probably don't have to tell, some people this, but litigation is incredibly expensive. I typically recommend to my clients when I'm putting together a contract that before they are able to run off to the courthouse or the contract allows the other party to run off to the courthouse and file suit, they really should include something in their contracts that includes what's called alternative dispute resolution, or ADR. An example of ADR is mediation. And for those of you who haven't had the pleasure of attending mediation, it's essentially a negotiation between parties through a third-party neutral individual who kind of shuttles back and forth with offers, seeing if the parties can reach kind of a negotiated resolution. If you can't reach a mutual agreement in mediation, then litigation and running off to the courthouse really might be your only option. But you may also want to put limits on which courthouse someone can run off to. And one way of doing that is by specifying the county that the action needs to be brought in. So the latter part of the sample clause that's on the screen, mentioning Thurston County is an example of that. So specifying what's called the quote-unquote venue for your dispute can really save you a lot of money. So for example, if you contract with a party that has its offices in Spokane and you have a dispute over the contract, you probably don't want them to be able to sue you in Spokane and drag you over there for an even more expensive litigation. So pay attention to venue clauses, particularly in contracts with large companies and out-of-state companies. Out-of-state companies in particular will often include clauses that say you have to come to New York, or you have to come to Florida or Chicago, Illinois, to sue them, even if the contract involves property or products that you've been selling in Washington. Next up is limitation of liability. So these clauses, they really permit the parties to the contract to reduce or limit certain types of damages that they can recover, and sometimes limitation of liability clauses will cap damages altogether. These types of clauses, they are related to disputes clauses, but are typically included separately in a contract. These clauses are not enforceable in all states. They are enforceable in Washington, but again, I caution you, just kind of check the local laws of the state you're doing business in to see whether or not this sort of clause is enforceable. In Washington, however, the clauses are generally enforceable so long as there's two things present. One, the clause can't be unconscionable is the word that the law uses. So in other words, it can't be shocking to a reasonable person. So for example, a clause limiting liability for faulty construction of an apartment building, a limitation of liability of $5, for example, probably would not be upheld. That's pretty shocking to think that a person who built, a crappy building would only be responsible up to $5. So again, something like that probably would not be enforceable. The other thing in Washington that the clauses need to include is they need to be conspicuous in the contract. So not in teeny tiny little writing or on the back of a page that no one would notice. It needs to be generally in the same font and the same size as the other clauses in the contract, just to make clear that you're not really hiding it. And here's a sample. So in no event will the company be liable to you for any indirect losses, including but not limited to lost profits or lost savings arising out of your use of the ABC Tech Inc. product. And I'll say that in, limitation of liability clauses, they really can be used as a sword and a shield. So if you can limit your liability, great. But a lot of times parties decide to limit liability because things like lost profits and indirect losses, also called consequential damages, they're really hard to quantify. And when someone is alleging a loss of a consequential damage, it can really lead to some really, really expensive litigation and generally just a lot of problems for the parties that are really just trying to do their jobs and finish a contract. So what if the other side won't budge? So the realities of being a small business is that, you really oftentimes find yourself in a David and Goliath situation. So during the presentation, you may have been saying to yourself, this is all great, Ashley, if I get to write my own contract, but how is what you're telling me going to help you if conglomerate company ABC, puts their form contract in front of me and tells me to sign on the dotted line or else, take a hike, no deal. I hear you. And, you can really still use the things we talked about today to build a good defense. What I mean by that is look for some of the clauses we talked about today. When ABC Inc. slides their form contract across the table to you, or generally nowadays it just emails it to you, look at it and look for some of the clauses we talked about today and at least educate yourself. Is there a short window period that I have to provide notice? Can ABC Inc. unilaterally modify my contract, or do they have to get my consent, my signature? Is my liability limited in the contract? Is ABC Inc.'s liability limited if, in the event I have to sue them? When you educate yourself, even if you don't have the leverage to draft your own contract with the terms that you want in it, or even modify existing terms that the other side may have proposed, you can at least educate yourself so that you can evaluate the risks and rewards of accepting certain terms. And you may decide after reviewing those terms that, the contract is acceptable to you. You wish that there were some other things in there, but you can live with those terms and you're accepting those risks. But then there also may be times where you look at certain things and the other side won't budge, and you say, this isn't worth the risk. There's not enough in here to protect myself, to protect my business, to protect my employees. And then you may decide, that it's not worth it and that you want to walk away. The other thing I want to say is it never hurts to ask for a contract modification. You don't know unless you ask whether ABC Inc. Is willing to modify their standard form. If they say no, then again, you have to make the business decision as to whether you accept the terms. But again, it never hurts to ask, particularly if you've got kind of a sound explanation or justification as to why you need or want a particular modification in a term. And so with that, there is my, oh, perfect, I did put my phone number on there. So again, my phone number and my email address are on this last slide. And with that, I will open it up for some questions.
Great, thank you, Ashley. I think that's wonderful. And even just, hearing you say, no harm in asking, I think that's wonderful. I don't see any questions in, so feel free to type them in or raise the hand if you would like to ask Ashley verbally. And it might be that you think of questions after the fact, too. You can also email. We've had different presenters from Old Morrison before, and you guys have always been so wonderful at answering questions after the fact. So thank you for that. It's always a pleasure doing business
absolutely.
With you guys.
And I know I can be a bit of a quick talker also. So if anyone has any questions, like Traci said, after the fact, happy to kind of talk through those, particularly if there are any other types of clauses that you like to include in your contracts or other types of clauses that you seem to come across all the time. Like I said, I could probably talk for a full week on various clauses that you might look out for or include in your contract. But again, it's not a one-size-fits-all approach, and some contract relationships need certain things while others don't. So
absolutely. So yeah, feel free to, even if it was one that she didn't mention, if there's something that you've stumbled upon that was confusing or you wish you knew how to modify it in the past, or if you're trying to come up with a contract, you're welcome to ask those questions as well. And if we don't have any, that's okay. It's never too bad to get out early. Oh, Laura, go ahead. I see you're unmuted, so feel free to ask your question.
Yes, I'm an artist, and how do you put in a clause so that the person does not duplicate your work?
That is a really great question, and I want to preface what I'm going to tell you with is that I do not know as much as I wish I knew about copyright law and trademark law and other laws that deal with kind of reproductions, not only of with kind of different mediums of art, but those types of clauses would be what you would include. So limitation of liability is one way that you can do it. Include in there not only kind of the standard language that we talked about before, but you can either include there or include in another clause separately that the work is personal to you or your business, and that it can't be reproduced in any format. I recently drafted a contract for a hairstylist who was putting videos on kind of a private video share channel of how to do hair and different coloring techniques. And she was actually selling those videos. And so what we included in that contract to kind of keep her protected were some pretty straightforward clauses letting the purchasers know that they couldn't reproduce the work, that the work was personal to her company, and that any sort of sharing, even if it was just kind of for innocuous purposes, had to be with the company's express permission.
Thank you, Ashley.
Oh, great. Thank you, Laura.
You're welcome.
And also we do have, if anybody else has specific like trademark patent type questions, we actually have a patent attorney come to our office in Lacey once a month that does free legal coaching. So I'll send that information out in the follow-up so that you guys are welcome to take a appointment with that as well. We had a question written in. So is a contract legal and binding if I write it myself having no legal background? Do you suggest writing the contract ourselves and then having it being reviewed by an attorney?
So I'll take the first one first. The answer is yes, absolutely. The essential elements of a contract, so offer, acceptance, and consideration is my law school answer for you. None of that requires a legal background. And the answer to the second question is, yeah, I actually do think that drafting a contract yourself and then giving it to an attorney for review is a really great way to do that. One, it can save you money, and two, simply because you've kind of gotten the ball rolling and gotten some thoughts on paper that the attorney can work with and doesn't have to go from scratch. But also, writing it yourself can bring up a lot of issues and questions that you might have that you otherwise wouldn't have or wouldn't have thought of if you had just handed it over to an attorney to write from scratch. And so all of that's a long way of saying that, yes, I absolutely think that it's a good idea to kind of at least sit down, and even if you don't feel comfortable writing, a full, 6 or 7 page contract, however long it might be, even just writing down bullet point terms and issues that you want to make sure your attorney includes in the contract is a really good idea, because then again, you're kind of guiding the attorney into the direction of the things that you care about and the terms that you would like to see incorporated into kind of the final product.
Great, thank you. All right, if there are no other questions, that's absolutely okay. I'll stay on the line for another minute in case you're trying to frantically type before we log off. But I can release you all. I know you have really busy schedules, and I thank you for your time, and Ashley especially, thank you. Unless there's anything else you wanted to add before we close today's session.
I don't think so. Thank you all again for joining me, and thank you, Traci. I really enjoyed kind of putting this together and going back and thinking about, some of the things that I tell my clients, and I think it's important to share with everyone else. So I do appreciate it.
Yeah, thank you guys, and watch for your email. I'll send out the recording a little later this afternoon once it's done being downloaded and processed and all that fun stuff. Have a happy Wednesday, everybody. Enjoy the day.